pretty eye. Goddamn. Damn, sooner or later, I'm gonna have a goddamn pretty eye mixtape, though.
Damn, chick, you doing another song for pretty eye?
I can't deny her, though. She's my bestie. She's my bestie. That's my bestie. Your pair of eyes had me paralyzed. Toxic nigga, but you made me to a better guy. Smoke, but with you on forever, ever. I can watch you all day, girl, like you're televised. You think like this nigga, they ain't never lied. I lived the beaches alone, I had to pick a side. Look in your eyes, girl, you were hypnotized. Of course, it was your breasts, hips, and them damn thighs. Close my eyes, I'm still mesmerized. Get mad at my bestie, I tried. That's my bestie, my pretty.
I heard she's the one, she's got it going on. That's my pretty eyes, baby. Yeah, yeah. She don't take no mess. My bestie is the best. That's my pretty eyes, baby. Yeah, yeah. I heard she's the one, she's got it going on. That's my pretty eyes, baby.
Hey, what's up? Anyways, I am here. I'm going to rewatch this because I screwed up my last live when I did it. I went to go edit it, and the piece I wanted edited out, I edited in and the rest out. So anyway, so I'm going to rewatch this, redo it, whatever. This is wild. This is the motion to dismiss hearing. It gets pretty heated. Not gonna lie. This is kind of crazy. I just, what prosecutors, cops, and everything get away with is not okay. This is the reason why we have the justice system, is to hold people accountable. All except for, they don't get locked up, and they don't, they don't have to deal with the rest. What's up, 3,000? They don't have to deal with the rest of the problems that us as citizens have to go through. They've been doing this for years. This is the first time I've seen them do it to a white person. I'm not going to lie. Well, we usually know who they target. But it's not about that. It's an American thing. It's a citizen thing. It's amazing what they can get away with, and how they put charges on people and think that it's okay to withhold evidence, not fully investigate, especially, okay, so, cops are supposed to be the protector, the whatever. They're held to a higher standard than us, and they should be, but they're not. They're not held accountable in that position. We just take them as fact because they're the law. They're the law pushers, right? They're the ones that make us stay in line, quote unquote. And we need to hold them to the higher standard, especially, this is wild because it is a Boston police officer that was unalived, and they're blaming it on her. Why? Because the place that he was found, lying there in the cold on the front lawn, was another Boston police officer's house. And the way they investigated this was bullshit from the very beginning. They didn't search the house, which any of us know, if somebody's found dead on our front lawn or on our property, our house is getting searched whether we like it or not. And so it's crazy to me. They didn't search the house because she had a busted taillight. They say that she hit him 22 miles an hour in a snowstorm, because they claim it was so snowy, but it was a light dusting on the ground. It just barely started snowing when they claim this had happened. And nobody saw him go into the house. Well, it doesn't matter whether they saw him go in the house or not. You should do your job and see if he did go into the house. You want to talk about, oh, there's no probable cause to go in their house. Yes, there is. There's a dead man on their front lawn. That's more than enough. So, anyways, it's a dead police officer on the lawn of another police officer's front lawn. Her taillight was broken in maybe three inches of snow when he was found. You know, they used leaf blowers and red Solo cups to put blood evidence in. They couldn't find nearly her whole taillight shattered all on the scene. They didn't find nothing until what was it, a day, or they had some special search team come in, and in a foot and a half of snow, all of a sudden they found magical taillight pieces, and his shoe and his hat and stuff like that, which was probably planted there. It looked planted, not gonna lie. It didn't look like it was found deep in the snow. And how can you find taillight pieces in a foot and a half of snow compared to 2 inches of snow? This case is wild to me. I would have threw the case out the minute I heard leaf blowers and red Solo cups. How can you not put a perimeter around the scene? How can you not put a tent up? All this stuff, not take pictures. No chain of custody, no logs for evidence, nothing. And DNA was found on his clothes, and it had 3 males. That would be John O'Keefe, who lost his life, and 2 unidentified males. And they didn't run DNA through the database to see, or didn't ask, people in the house for blood, for DNA. But they're just going off of whatever, They found a magical hair in a snowstorm when they towed her car to a police department that was supposed to be recused because of the family members and stuff like that related to the cop that's house he was found in. They didn't ask them for DNA, but they took 2 of the investigators' DNA, which is wild to me. 2 of the police officers that were in the house that night magically, got rid of their phones when they were asked for evidence to download their phones. They magically just, threw them out, threw them away, got rid of them, did away with them on military bases, such as such. The only shady thing with Karen is she was texting another one of the guys in the house, probably just for some attention. She probably felt, her and John had been together for 2 years, and she wasn't feeling loved anymore. She thought he cheated on her. On a holiday, vacation. She said that he kissed another girl, so she kissed another cop. And that night, it looked like the 2 cops that were in the house the same night with John O'Keefe, when John O'Keefe was found dead, they looked like they were trying to egg on a fight in the bar footage. She was drinking. She has not admitted that. What else? Just this case is wild. So yeah, they love to do this to citizens. You know, she is paying like $5 million to be defended. $5 million for her defense. And that's sad. And she's got to go through this all over again. She already had one trial that ended in a mistrial. And now she's going through this again. Why? Because they want to bleed her dry. Bleed her dry. And what's sad is John O'Keefe's family is not upset by the crappy job that the police officers did in this case. They just want to see her convicted. Well, if she's not guilty, putting her in jail is not getting their loved one justice. And I feel like he needs justice. Like this should be about getting justice for the victim, not who you like and don't like, who you're cool with and not cool with. Because I know there's a little tangled web we weave, you know, throughout this close-knit, you know, family. He was the only outsider, and she was, you know, she led somebody on, and he wanted to fight her boyfriend over it. So it's just weird to me, this whole case. I could go on and on and on, and I'm probably rambling and not making any sense. So I apologize for that. I have so many thoughts going through my head. But anyways, let's get right into it. So I'm not here all day because I've already seen this. You know, I've already watched it on live, but we're going to do a rewatch. So hope everybody buckles up. Please hit the like, share the live, comment if you'd like. I appreciate all the love and support I could get. You know, I'm a small YouTuber, you know, trying to make my 1,000 and my 4,000 watch hours so I can get monetized after I don't know how many years I procrastinated on my channel, and I'm finally starting to get serious. So anyways, let's get into it. I'll probably wait like a minute or so till they come on. And they don't waste no time. Like, they really get into it fast. Anytime now. Come on. Hurry up, sir. Ma'am, sir. Sir, ma'am, sir. Sir, ma'am, sir. Sir, ma'am, sir. I'm going to have to try out this new feature that StreamYards has, but not now. Okay. I think it's, here we go.
Dismissed for extraordinary governmental misconduct, a true and correct, to the best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So the fact, what you state as fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that, and I'd like you to start there.
If the court
See, she does this to the defense all the time. She doesn't let them just, go through their motion and whatnot. No, she always has to go directly to what she wants to hear first. It's never like, oh yeah, just run through your presentation like you need to, or she interrupts them 5 million times. She never really does it to the prosecution, even though she says, oh, just like I did Mr. Jackson, I'm going to do it to you. But then she really doesn't do it. And she doesn't call them out on their shit. And, he finally says, I want the same discretion you give the defense that I want you to give it to both sides. Don't just throw it at us and let him get away with gaslighting and lying and all this other great stuff. But we'll get into it.
If the court recalls the discussion at sidebar, we were told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court.
Okay, let me move this. Why is this not moving? Oh. No. Just maybe put it there. We'll see.
With no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that because that was the next conversation that we had. When we were told
let's see if that works. I don't get to see it, but that's all right.
On the day of closing argument, to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct.
Heard from a herd. Yes, that's right. Heard from a herd. I remember this. When that juror got dismissed, the defense wasn't too happy because she was leaning towards the defense, and they thought that, they had a pretty good chance of beating the case with that juror. And somehow, some way, they made it. I mean, they brought it to the court's attention that supposedly she was talking about the case and somebody overheard her. Somebody took video of it, but they never showed any video of it. They asked to question her. They wouldn't. The judge denied it. A whole bunch of crap. Like, there is so much governmental misconduct. It is beyond belief. And this judge is part of it. She's very biased. This is her last criminal case, and I really wished that she would have gave up this case too. I don't know who's paying her or what they're paying her, but yeah, they're doing anything and everything not to let Karen Read have a fair trial, because if they let her have a fair trial, oh no, they're going to get exposed, and maybe other Boston cops may go down for it.
We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously recognized.
You were not, just so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by.
Okay, no one said it was you, Judge. See, you're taking this a little too personal. Maybe if you would have made the right judgments along the way, maybe you wouldn't have to. Maybe you wouldn't have to backbite and nail bite. Maybe you wouldn't have to try to find any little thing to come at the defense for. It's pretty sad to watch this. It's truly sad. But anywho, they got rid of 3 jurors that were possibly for Karen Read. So what's up, West Adams? Salute.
Ms. McLaughlin,
Thanks for coming in.
she's the one that indicated
I know you
that
won't
it
stay
was
long because a
reported.
lot of people aren't into
I'm sorry.
chat, but hey, I love them.
That's not
And it gets me out of the drama. But salute, West Adams. I appreciate you coming in.
right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury?
Your Honor, I'm getting to that. I understand that, but if you'll allow me to make.
Right, she ain't gonna let you get. She is taking this so personal that she ain't gonna let you ever get out your arguments, Jackson. You already know that she has a disdain for you. And I gotta move this. Seriously, I gotta move this. Why is this not moving over? Why? Why are you not moving over? Okay, whatever. Anyway, so she's got a real disdain for him because he's a California lawyer, and this is not what we do in Massachusetts, Mr. Jackson. She always tries to get Yannetti to back her up, and he never does because he knows the bullshit that she pulls. But anyways, okay.
The argument and to indicate what as my declaration says, my good faith belief based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was
Don't laugh at me. I know I'm funny looking, but don't laugh at me. That really hurts my feel bad. Anyways.
Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration. There was no report. There was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember, no, that was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control.
What is up with the extensive security, blah, blah, blah? He's also the one that brought the supposedly juror misconduct to the attention of the court. He's also the lead investigator's supervisor that was on those text messages that he was writing about a defendant. The sick text messages, mind you, talking about her health, medical conditions and talking to friends about the cop's death and one of his friends says, so, what about the cop? He ain't gonna basically, he ain't gonna get a lot of shit for this. And he's like, no, he's a Boston cop too. He wanted to pin it on her the minute that they asked him, period.
All over the jurors.
It says that
and I'm just going to stop you. I'll let you finish in a minute.
Even the DA got the nerve to get on all the local television news stations claiming that she is not presumed innocent until proven guilty. She's already guilty. that shit, this is a bunch of bullet BS and all this other dumb, stupid stuff.
Eddie, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander.
Do you see how upset and mad she is? Like, okay, but see, your prosecutor gave him that information, ma'am. So if you don't like what came out, that's on you and your and the Norfolk DA and the freaking Massachusetts State Police and the Canton Police Department. You're all in cahoots at this point. Do I believe, the conspiracy? I'm starting to, because there's more evidence supporting that than supporting the case that they're bringing against this woman. There is no injury on that man that looks like it was from a car accident. You don't have multiple lacerations on your arm from a taillight. Oh, because he hit his taillight again, his elbow against the taillight, and it flung him in the air, made him do a 360 pirouette, and suddenly he crashed his head onto the ground and then slid 30 feet. That's what they want you to believe. All from her backing up 22 miles an hour in the snow. I doubt she was backing up 22 miles an hour in the snow. Even their little key data bullshit from the damn car proves that the time that they're referring to, that was the time of the incident, or the key ignition time of the incident, was actually the time that they were backing her car up to get it on the tow truck. Why is there no freaking pictures of the taillight before they even tow it? Because that's usually protocol, that you're supposed to take pictures before, after, all that stuff. You're supposed to do that. And any and all video, digital evidence in any case should be preserved. Whether the defense asks for it or not, it is part of the case. And whether you like it or not, you're saying her car was the murder weapon. So why not? Why, for the love of God, don't you turn over the whole day's evidence? Why? Because it supports the defense's theory? Because I'm starting to believe that. I'm starting to believe, with all the butt dials, close-knit relationships between everybody, the lead prosecutor, the family of the Boston cop that he died on the lawn, all this great stuff, and a lot of them, mind you, have all. Well, not all. Okay, him right here and one of the cop's brothers were both in a drunk driving accident that involved a pedestrian. One killed a man, one permanently disabled a man. Guess who paid for his attorney, though, for his case? The woman he's trying to pin his brother's murder on. Imagine that.
Of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, but Ms. McLaughlin told us, we were told he was the commander, not part of a security operation that was outside the court, not part of a security operation.
But I bet you she'll deny that she told you that, Jackson. You know that they ain't going to tell the truth. You know that they're slimy, undercut BS.
Cars, or making sure that
they're trying anything and everything. They wanted to use her trying to get in contact with the freaking attorney that morning when they came and got the freaking video. The car. Because she knew she was drunk driving. She thought that's the least that they were going to get her on. She didn't know that she was going to end up with manslaughter and a murder charge. But because she tried to get in contact like everybody should, the minute you have any police interaction with a lawyer, they want to use that as consciousness of guilt. Well, when that didn't work, now they want to use a blogger, saying, even though, it went to the grand jury and never made it past there because there was no evidence of witness intimidation. But they want to go ahead and bring those in. This is absolutely crazy, dumb, stupid. The law sucks sometimes.
Citizens got in and out of the courtroom.
I'm just glad for right now that it's being exposed. I'm glad that I'm glad for COVID, because if it wasn't for COVID, a lot of trials wouldn't have been mainstream. And we need to, just because it's not a celebrity on trial, we still need to see the comings and goings of courts, what they do to people, but 90% of the time, when you have a prosecutor that only wants to seek truth and justice. They don't care about a win. Yeah, they just want to see the right person behind bars. When you see them in court compared to this crap, you know who's good and who's bad, because they don't pull the same stunts that the Commonwealth had pulled. They don't pull the same stunts that they did in the ASAP Rocky case. They don't pull the same stunts as they did in the Alec Baldwin case. But I digress.
Appropriately, we were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
you were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was: commander of the extensive security operations of the court. So,
okay, you have the transcript. You always say, I have the transcript, but you never read the freaking transcript, lady. You didn't pay attention to the freaking trial. You just go with anything and everything that the Commonwealth does and says. And you make them fight tooth and nail. You make the defense fight tooth and nail. When it came in that she backed into his car that day when she went to go to Jen McCabe's house to go look for John, you took that, and went and looked at it and said, let me look at this. You looked at it, came back, okay, yeah, she did hit the car, right? But now, and when this comes up, she's like, oh, well, I don't see nothing about Detective Barros's statement about 47 pieces. That was the Commonwealth's theory. There was 47 pieces that they put back together on the taillight. And what's funny is the only piece that they couldn't find was the piece that she broke off because she hit John O'Keefe's car in the morning going to look for him. But you guys claim that she ran him over. But okay.
So we reasonably concluded that he was either directly in charge of the jurors or in charge of the...
Oh, and purposely left him there to die. I doubt that, but whatever.
The people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time in good faith. Both Mr. Yannetti and I asked the court to take evidence from Lieutenant Fanning.
I think it was Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So, of course, that's one of the issues that is attendant to our motion to dismiss because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source report to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
Your Honor,
Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized?
Is
Now
there
that you
evidence
know
that-
it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly. I take
So
the court
we
at its word.
will move on from that, Mr. Jackson. We'll move on from that. So
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason, because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case. And he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly. And the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror. That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
all right. So that's your answer to my question.
That's my answer to
May I
the
have a moment
question.
to confer with counsel?
Yes.
Thank you for that. The court invoked Mr. Unetti and said, as local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact. And so Mr. Unetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Unetti. So if the court would allow Mr. Unetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
I'm happy to, Your Honor, and thank you for giving me the opportunity. The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers through their agents, has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory Sally Port videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sally Port issue, or the Sally Port video issue. The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. While they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of D. Giampetro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sally Port video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but it could be available.
I'm just curious. So he's still around?
Yes,
Okay.
yes, and it's cooperative.
All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Canton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022.
Okay, see, stuff like this is really asinine. Okay, they have trickled evidence. They have definitely what do you call it? They've definitely doctored up videos. They put in an inverted video and portrayed it as being true and accurate during trial. That's what they did. Yet they're asking for the full day and they're not giving it to them. The full day of the death of the officer. This is absolute bullcrap. They have been withholding that evidence. The FBI had to get involved and all this other stuff. The FBI case supposedly is done, but I don't know who. I mean, anybody who knows the FBI, their case is never done, and they don't simply call and make a courtesy call and say, oh, our case is over, especially if you're a target of the investigation, which the state was for the mishandling of evidence. In this case, in the Sandra Birchmore case, where another cop was involved and they claimed it a suicide, but really he strangled her to death, and the FBI got involved in that. So many players from that case are in this case. Then they got the freaking dude from that dude that stole the painting, and got for fraud or whatever, blah, blah, blah. And then his wife is missing. They're in that case too, but that dude's actually guilty. But anyways, I mean, they know how to do real police work. But in this case, they failed. Whoops.
That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th,
nor did they give you the metadata that is attached to these said videos. Why? Because they're doctored. If they show you the metadata, then that exposes them even more. I don't know who in history ever has video evidence and not metadata to back it up. This is crazy.
And I want to walk through what videos we did get and when. On April 4th, we got 2 videos. One was the Sallyport interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sallyport. And we also...
Yeah, where is that 42 minutes? Why? Because the lead investigator wanted to put it that the car didn't arrive until 5:30, but it really got there an hour early. Because if it showed that it got there at 5:30, there would have been more than enough time for them to break that taillight fully and, place it on the ground in the snow, where they miraculously uncovered it in 1.5 feet of snow. But in 3 inches, they couldn't find it.
Also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car.
Nope.
On April 23rd, 2024, and by the way, April 4th, the court...
And any of the pictures that they have of that car was after they were doing the search warrant. Not before it got towed, not after it got towed, not when it got the crime scene blocked off on it. None of it. And you're telling me, oh, it's motion activated. Well, when there was motion in the garage, why wasn't it filming? They know it was filming. They know they couldn't hand it over. Why? Because it would show that it came in an hour early, and there was people behind the car messing with that taillight. You can't tell me it's not. And then miraculous people go in and out of frames and stuff that weren't there before, which is really funny to me. They try to make people disappear in that footage. Couldn't do a very good job, but they tried. They definitely tried. And still, they won't hand over anything at all. They trickle these little snippets of it to the defense, but no metadata. They say, oh yeah, you can come and download it from the hard drive and blah, blah, blah. They spend all this money to send out an expert to do that. And all of a sudden, oh, we don't know. It's nowhere to be found. But then that day, oh, well, yeah, it's because it's on a detective's drive. Okay, so, and then you won't reimburse them for the expenses that they had to pay for the expert to go out there. I mean, you're trying to drain this woman for everything she's got. She ain't did nothing wrong, but dropped the dude off where he wanted to go. And she left because she was having stomach issues. Because why? She has Crohn's disease. She has MS. Obviously, she couldn't stay there. Her stomach was having issues and she had to go take care of herself. Understandable. He was only supposed to go in for 10 minutes to find out if it was okay to stay anyways. But then when she was calling him and texting him, nobody's picking up the phone. Nobody. And the dude that was egging him on at the freaking bar texts him and says, you coming here? Why? Because they wanted a fight. The fight got out of hand and someone lost their life. Mutual combat is not against the law. But when somebody dies during that mutual combat, then it's a problem. And I don't know that case fully. Does it look like he was in a fight rather than ran over by a car? Yes. He doesn't have no injuries from the neck below, all except for his arm, where there's lacerations like he was bit by a dog. He was attacked by a dog. It looks like that, whether you want to believe it or not. But they're trying to say that those 47 pieces did that to him. And because they found taillight pieces in his clothes that they, chain of custody, nowhere to be found. Chain of custody wasn't even there. I mean, they didn't even put it in evidence until 3 days later. Oh, well, it was wet, so I had to let him air dry and all this other stuff. But yet you found these particle pieces in his clothes. Maybe because, that's probably where you put some of the taillight. So you could frame her. But why didn't you test the DNA on his clothes? There is still 2 unidentified males that they haven't linked the DNA to. Why? There's a cop's house that they didn't search that morning. Why? They're using leaf blowers as red Solo cups to collect blood evidence, not even stored in a freaking environmental safe place. Why? Why was the blood evidence sitting in the back where her car was? Were they trying to, plant blood evidence on her car too? This case reeks. And when they say you meet the description, boy, they'll try anything and everything if they're not about abiding by the law. If they're not a legit by the book prosecutor, they're going to do anything and everything to prove that they got their man.
Court will call was just in the shadow at the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sally Port interior back.
Laugh out loud, Kevin. Hey. Laugh out loud, Kevin. Hey. How are you? Man, this kiss is dumb.
Well, video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant DGM Petro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear light.
Oh, so you mean after this, crime was committed? Oh, wow. You found 4 after the whole trial went forward and it went into a mistrial. So we got to do this all over again. You want to trickle off more evidence, more videos to the defense? It's exculpatory because you're hiding evidence. That's what's exculpatory about it. It's exculpatory because it's the murder weapon and it's in that freaking, it's supposed to be under surveillance for a whole day. Well, actually more than a day, but still. In a police department that was supposed to recuse themselves because of conflict of interest. Because there was family members of the cops that the other cop was found dead on his lawn's family. They're protecting their own, but only the living own. Man, if you're a dead cop and you land, man, I feel sorry for you because that thin blue line is really thin blue. They don't protect you anymore. They care less. And his family believes it. This is sad.
Lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior.
His mom from day one blames her. Why? Because she left him there. She left him there by himself. A grown-ass adult. But it's her fault because she left him there. How is it her fault? Did she know what was going on? No. But I bet you the police in the house did.
Exterior Sally Port. And I highlight the word exterior because it becomes extremely important in just a moment.
Kevin, this one been crazy. I mean, this is going into trial too. This is their motion to dismiss for extreme governmental misconduct. from the bullshit investigation to the bullshit people involved to the bullshit judge that's biased as all get out. And because one prosecutor couldn't do the job, they had to go and hire a defense attorney to probably defend the DA because he's got his hands all dirty up in this motherfucking thing. Why? To protect cops. She's an outsider. She's not a cop. She was only dating the cop. He's an outsider because he wasn't a part of the family that it happened on. So they basically killed two birds with one stone.
These are 4 videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022.
They're saying that she ran over him in a snowstorm. Well, it was barely snowing, but still 22 miles an hour backing up and hit him. That's what they're saying. Yet he doesn't have no injuries. He has head injuries, like he's been in a fight with a boxer. I'm not going to lie. And his arm injury where it looks like a canine got to him. But other than that, he has no injuries that are consistent with being ran over by a vehicle. The FBI even said they can't, in good faith, see this case going forward. So they released everything that they could. And they still went ahead and did it. Because why? That it happened on another cop's lawn. We got to protect the ones that are living, not the ones that died. Whether it is by the hands of another cop or not. It's damn shame.
Then on January 28th, 2025, the Canton Police Department main driveway side exterior sally port was given to us. It's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior sally port video that we ever received. One on October 10th, one on January 28th, 2025. And then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick, dated February 28th, which is 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior.
Now this right here is wild. What he's going to say right here is really wild. Mind you, he got the video evidence from where her vehicle was, and it has a Post-it note. But just wait what this Post-it note comes to.
To testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior sally port. Exterior sally port. That means that the Massachusetts State Police not only had in their possession exterior sally port video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one.
And they still haven't gotten all of it. They've only gotten what they'll release to them because, they're not trying to get their own hemmed up in this,
January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 2025. And they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination.
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly?
Same.
Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly anything.
Yeah, because they had to doctor it up before they handed it over. I mean, come on. They're trying to say, oh, yeah, well, our cameras were fuzzy. Our cameras were bad. Nah, just wait till what pops up when they show evidence, what they've been editing with.
No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchnick watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024.
And what's funny is now they want to give them reports. Where were all these reports and, memorandums, memorializing the whole crime? Where are those reports? Oh, that's right. You lost him in a fire or something, maybe? Maybe you lost him in a fire. Or maybe you just didn't take any.
He admitted to that on cross-examination during trial, but I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it across. This is binary. It only happened one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute. On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the...
Oh my God, lady, really? How is that exculpatory? When you're withholding evidence, you already went through one trial. You already gave them BS tapes, no metadata behind it. Also, you gave them an inverted video that you played for the jury and tried to pass off as, oh, there's nothing to see there. It's fair and true and accurate. Nothing was tampered with type deal. To the jury, they're supposed to believe this, right? But the jury isn't supposed to know anything about the case, which is crazy. Like, I don't know how they don't know about this case, because at this point, this is beyond, this is international. And it could happen to any one of us. That's the sad part. I mean, she was a freaking a financial professor, which is crazy.
The presentation of my oral argument, the fact that those videos all just happen to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the...
Exactly. They don't want to show the real condition of that Sallyport video. They don't want to show it. They're afraid to.
The taillight to be seen by anybody when it's pulled into the Sallyport. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice.
Oh my God, lady. Can you hold on? Can you let him make his arguments? Then you ask your questions at the end. You're just as bad as me interrupting. I mean, I'm interrupting him during his information, but see, he can't hear me, but he can hear you. And you do this only with the defense, never the Commonwealth, when they have the burden, not the defense. You're burden shifting, and it's not okay.
As I move through
now or no? If you can, if you're going to do it later, that's fine.
I will do it later.
Oh my God, lady, let him do his job. He knows what the freak he's doing. Just because you're impatient.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided. Okay. It's just very obviously. There were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out They all find their way to be defective in one way or another.
And also what's funny is when Brennan gets up there, he says, oh, well, just like any case, sometimes you miss evidence. Da, 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 da. Mother effers. You don't miss one of the key pieces of evidence in a case unless you're trying to hide something. You're trying to hide something. And it's prejudiced against her because it's not giving her a fair trial. By not giving her the evidence in time for trial, not trickling it off, not tricking it off, not, saying, oh, well, we can give this, we can give that. The only reason why they know certain pieces of the evidence is because the FBI got involved. But okay.
At the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true? And we're still getting video evidence that is in their possession, custody, and control in October, in January. How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago. And they're now adding to their exhibit list and to their opposition. But at the point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this.
You know what I'm wondering? Since they already went through this case and whatever, blah, 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 blah. What I'm wondering is whatever evidence that they're trying to put in for exhibits and stuff, I'm just curious. I'm wondering if they can use what they used before and what they use now against them in a trial. I'm just wondering if they can. Because I guarantee what they used before and what they're trying to use now shows the evidence for themselves and not for him, not for her, not to benefit her. Any doubt should go to the defendant. Any question, like if the Commonwealth doesn't answer your questions, if you have more questions than answers by the end of the trial, she's supposed to get the benefit.
Joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time, is because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that we're.
Hey, Trey, thank you. Also, put your link in for other, pop culture stuff, your breakdowns and all that great stuff. Please put your link in. Sub up Trey. He does great breakdowns on trending topics that are going on with the hip hop community, with, cases, stuff like that. And his breakdowns are one of the best.
That I'm explaining to the court about the turning over of these Sally Port videos, specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with.
I always like to read along. Where does it say it?
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs, crime scene photographs in support of the vehicle in the Sally Port. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sally Port. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was.
No need to thank me. One day I'm going to get like you. I'm going to be able to I'm going to be able to get out what I'm thinking and saying at the same time. Like, I'm an introvert, so it's hard to be an extrovert, but you really do great big breakdowns, and you give good insight. You also give teaching moments where young kids need to learn, they could learn from it if they actually, sat down and listened to you, because you're very smart, wise, and you don't just talk about what's in the news. You also try to bring life lessons into it. Like, so I appreciate you. That's why I support you. So everybody sub up 1250 podcast, because he is one of the best to ever do it. And he needs more recognition than he gets.
Was turned over to us. So it's the condition of the car at the time that it was brought into the Sally Port on January 29th at around 5:30 p.m. that matters. That's the only time that matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton Police Cruiser at 8 a.m. and the independent observations of Dighton Police Officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sally Port. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sally Port. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sally Port at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41. 11 minutes, long after the car had already been secured in the Sally Port, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. It's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in the Canton PD Sally Port is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sally Port. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video. It's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostled, rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sally Port. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us, on the time that it got there. No, the defense is all wet. They're wrong. They just didn't account for daylight savings time. Oh, no, this was just a little mistake. It's not a big deal. It was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that car was in Michael Proctor's possession at 5:30 and pulled into the Sally Port at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sally Port until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sally Port, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it. It's their struggle to acknowledge it. Of course, that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sally Port, would it show the condition of the taillight before Trooper Proctor had access to it in the Sally Port? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. That is, this is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has. So we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sally Port videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sally Port because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, DA Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways. They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sally Port until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sally Port video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581. And this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor. Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sally Port where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchnick and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video? from the Sally Port? Answer. I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor. I
Okay.
didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish,
Of
that
course.
would be helpful for my review.
I haven't reviewed it, sir, in
Oh,
quite
sure.
some time, so I can't recall what's on there. Question. Why did you review video of the Sally Port? Answer. We review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchnick. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact. By his
So
statement,
she won't see it
Michael
like
Proctor admitted that, quote, we
She
pulled,
won't see it like that.
end quote, the video.
She's very
That video
bright.
is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C is in Charlie. The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days
Mhm.
to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Sally Port at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video. That was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly 2 in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least, but it certainly doesn't
It's not
define
single if it's multiple.
who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal material.
Were those all from the Canton Police Station?
I'm sorry.
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these.
Yeah, actually 3. 3 years they have been doing this. They already went through one trial. It ended in a mistrial, and they're trying it again. And this whole case is bizarre. And she's just loving it. I mean, the victim's mom is just loving this. I mean, it's sad that they only see her as the guilty party, but not the actual people that, you know, he may have died at their house. He's an adult. He has to get dropped off there. She dropped him off. It's not her responsibility to take care of another adult. Because adults are going to do what adults do, period.
Existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time. And it took 2 months to produce an incomplete production of these videos. We didn't even get all of it at the time. The Commonwealth writes, quote, "The quality of the video is poor in certain portions. However, this is the condition it was recorded in." Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper.
The Commonwealth is responsible for anything and everything that the police hand over. If they're hiding it, if the police are hiding evidence, that falls on the prosecutor. And I wouldn't take the fall for nobody. I don't care if there's a thin blue line, a thick blue line. I don't give a
fuck. Hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us. And Mr.
And what's even funny there is he didn't recognize the evidence when they put it before him. He didn't recognize the evidence. He says, that's not what I gave you. Well, wait, what'd you give it to him on? And why aren't they using that? They should be using that. Why are they using what they doctored up? It just seems like they've doctored up everything. I mean, they allow in screenshots of text messages, not actual text messages and metadata to back it up, but screenshots from other so-called witnesses in this case. Or if you want to believe the conspiracy part, the suspects in this case. And also screenshotted pictures of somebody that claimed, they were at the house but wasn't there when Officer O'Keefe arrived, yada, yada, yada. He had his cousin come pick him up. Yeah, but her info says something totally different than his. But anyhow.
Brennan used this phrase.
And they had that phone data to back it up. And the one thing that cops use to pinpoint a suspect in the area is cell bright data to show what tower you're pinging on, where you're at, the GPS locations. And the only one, they got one of the girls' phones. They downloaded that. But they're saying, oh, that search she made at 2:27 on Hawes Lawn to Die in the Cold wasn't really made at that time. It was actually made at 6:30. She left her browser over and it was in a sleep state, and then it woke up and gave a different timestamp. Absolutely dumb. Bonkers.
Not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as.
That is crazy. I didn't know that. Hold on. He said the camera that they replaced is the camera that they actually got the almost clear video. It still had some problems, but it was inverted, and brought to trial, made to seem like the passenger side was really really pointed at you, and when it was really not, to make it look like nobody went by her tail light, but actually they did. That is crazy. That's the one that was defective. Wow. Why was it defective? Oh, because it showed a clear video? Okay, gotcha.
Defective. A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Oh my
Probably
God, lady. 45 minutes.
45 minutes, let's say.
All right, so we'll break.
Anyhow, yeah, this case is wild. The one that was defective, so they had to replace, is the only one clear video that they actually got. That is wild to me. That is so wild to me. But the other camera facing the other way, supposedly, the one that showed, a dark, grainy footage that you could barely see anybody on it, that footage, that camera didn't get replaced. Isn't that the one that's supposed to be defective? But okay. Let me go through. I don't know if anybody else caught that. That is crazy. The only one that was defective, that was replaced because it was defective, was the only one that showed it being, wow. Come on.
All right, Mr. Jackson, go ahead and continue.
Thank you, Honor. When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know if it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally, perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them, and that's the galling issue. Then the Commonwealth writes, the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchnick with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth during this debacle had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchnick under direct examination by Mr. Lally, going into the next day, still under direct examination by Mr. Lally, They played that video
Sure did.
completely inverted.
Sure
They
did.
talked about it. They discussed it. They described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least in its initial comments to me, was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion. I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court, that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. It's he's on the other side of the car. That's not the point. The point is, a reasonable inference is he could have touched it.
Wow,
he was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around and obviously was standing there for a reason, by himself, in a corner, out of the view of the camera. And then when the Commonwealth plays the video, it switched. And the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that.
And you cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more.
They shouldn't have to clear it up. The prosecutors should know better. The prosecutors should know better. And you just let it fly by, lady. Fly by. But any little thing that the defense does, oh, you're down there, you're ripping them a whole new one, huh? Absolutely biased. I tried to give you benefit of the doubt, but I fully believe that you don't want to see a fair trial. You just want to see a conviction just like the rest of them. And it's sad.
More in detail what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing.
Yep.
Even after the trial was over, it was concluded, and mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutor sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR?
Why
the
were they
original?
playing games?
Where are the copies? These are questions for which we need some facts. And the fact that those have been
Playing
withheld
games.
from us is
Up
exactly
around,
the
up
kind
around
of
till someone
bad
loses
act
an eye.
and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this
But she'll override it.
same issue, the Commonwealth recites this now
I mean,
worn out sentence. The prosecutor was unaware of the existence of
After
these
all,
videos.
she's letting in supposed experts. I don't know what they're experts of, that have no degrees in whatever field that they're going to testify to for the Commonwealth. She's going to go ahead and let them in. But man, when the defense had to do one, they had to go through a 2-day hearing with her and then said it was a very close call. Wow.
End quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an.
Please hit the like, share the live, so I can get more people in here, so I can actually, reach my goal of 1K, my little goal. I want to be monetized by this year. I want some YouTube money. I don't really care about anything else. Just let me get money from the company. I mean, basically I have to sell myself in order to get that money. So please help a starving YouTube streetwalker some payment. Get me on their payroll. Don't treat me like a $2 hooker. Give me some money. Anyways, please like, share, subscribe, all that great stuff. Thank you very much. I appreciate all the support I can get.
Formal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them
somebody leave
at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote. LOL, laugh out loud.
Why would the chief of police put on a notepad that says no tampering, LOL? Wow.
So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations.
And what was the date? 10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DG Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of the trial, I think it was Mr. Lally, maybe Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. additional reports from the Commonwealth. In a report from Sergeant Petro, he reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume, because I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report, I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote, due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting. This is the first we're hearing of any of this last Thursday. How is that? Sure. Ms. Little just handed me a clean copy of the DJ and Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes.
You probably did.
So I've seen it.
Okay. May I approach it?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if that's all right, Your Honor.
Sure. I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes.
Okay.
So are we marking it? So we need it if we're marking it.
Oh, I'm sorry. My mistake.
Exhibit 1, so mark. Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DG and Petro, he downloaded every single bit of video of that car while at Canton PD in Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. The only two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DJ and Petro, quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out for the first time that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DG and Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember, his quote was that you and I believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is Chief Rafferty held on to it. She never turned it over. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchnick's actual report. As I indicated, he wrote a report last Friday as well.
You can't railroad somebody with correct evidence, man.
Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to KARENREAD. This was the spring of 2022. He knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's sometime early spring of 2022. That's the best he can do.
Hey, West Sider Rider. Don't you
Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD
now,
for additional video
I've
and it was
already
ready
watched
to be
this
picked up.
before. I have to
Since
watch
the Canton
it
Police Department is conveniently located on my route
because it's a
of travel to
5-hour
work, I
lunch.
stopped by and picked up the CD
And I'm trying
from
to
the front
put my
desk of the
time
police
down.
department, which was labeled Trooper Buchanan with a yellow Post-it note.
Follow the bouncing ball.
I further added Canton PD 12922, and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. There's a second CD now in July of 2023. I
Be starting to sound like Charlie Brown's teacher because, you know, he's in his bag. He's got motion going, baby.
did not review that video at that time. See the attached copy of the Post-it note. Final paragraph. In my preparation for trial in May of 2024,
Whoops.
I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little different.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No, it's pretty vague. It's passive voice and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony. So it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Sally Port, which was grainy and had a camera vantage point from the front of the Sally Port. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sally Port camera vantage point. I had not seen this video prior to my May date review.
Oh my gosh.
I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned. Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
Are there two still, Mark?
So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought Mr.
No,
Jackson just said he had an
you
extra.
want
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
Do you have an extra copy? Is that one clean?
No.
Who knows? No. That was the only copy I got.
May I approach, Your Honor?
This one has highlights on it. I apologize.
It's okay.
What do you mean? Where do I find these, Kevin? I find these on, the trial TV shows, like, crime, court TV and law and crime. That's where I find these. I just find cases that I'm interested in, and then I bring them. I found them in a Cracker Jack box. That's where I found them, Kevin. This is our prize. I mean, shoot, got to make court a little bit interesting. Otherwise, people aren't going to pay attention, right?
Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is, who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's it?
Don't question my greatness, Kevin. Okay? Just roll with the punches. No, I just different cases that I'm interested in, I find.
The center of all these Sallyport videos? Who does he say was requesting the Sallyport videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe?
Kevin, let me be great. Just let me be great. Anyways.
Most reasonably would have supplied the information to Sergeant Butnick to review. It stands to reason, could have been Trooper Proctor. Seems to be reasonable, but I don't know because Trooper Butnick doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing. Michael Proctor was receiving the footage directly from DG and Petro, dating all the way back to February of 2022. He was.
What's sad is they never had an evidentiary hearing. And, the least she can do if she doesn't grant this dismissal is an evidentiary hearing. A freaking preliminary hearing. Show the evidence where it may lead. But they're afraid of that too. Because why? They're corrupt. I'm believing corrupt. I'm not fully believing in, the conspiracy that they say. Yeah, because I still need more evidence. You know what I mean? There's still doubt. But yeah, I definitely don't think she's guilty.
The one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years.
Ever. Hood, don't ever in your life question my greatness.
Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it.
But yeah, you'll get the Commonwealth up there, and they're going to try to discredit everything Jackson says and all this dumb hoopla, mischaracterizing the evidence. And then they're going to show up on their little screen that, some pictures. And they got an AI editor on that.
Michael Proctor lied during his testimony,
Imagine that.
but he knew that we couldn't impeach him. There's no way I could impeach him. I didn't have any of these videos to impeach him with because we didn't have any of the evidence that had been secured concerning that Sallyport. There's surveillance video from Canton Police Department, Sallyport Garage that wasn't turned over, right? Answer. That video was discovered later on.
Evidentiary hearing. I can't say that word right, but yeah. Evidentiary hearing. Basically, they need a trial about the evidence. Show us the chain of custody. The chain of custody. Show us the evidence logs. Show us everything you're going to put forth. Like, these videos that he's going on about that have no metadata to back it up. Show us text messages other than Karen Read's phone that have metadata that back it up. They can't do that. Show us that, you dotted your I's and crossed your T's, or dotted your T's and crossed your I's. Show us that. They haven't done nada. Not a single solitary freaking cream crumb, nothing.
On and then hand it over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing she
I'll provide that to you
can.
in just a moment, Your Honor.
Oh, you mean, how do you get hit? How do you hit somebody when nobody ever backs up at 22 miles an hour? Nobody. Even with the backup camera. There is no way in hell, unless they're shit-faced drunk, and I don't even know of anybody that would back up 22 miles an hour when there's snow on the fucking road and hit somebody. And the only thing you crack is a freaking taillight. Imagine that. And there's no broken bones on his body except for his face, where it looks like people bopped him in his eyes. I mean, the dude was swollen in his eyes. He had a fracture on his eye. Then he had a long gash and a fracture in the back of his skull. Yeah, those are fight marks to me. Those look like he was used as a freaking punching bag.
June 10th?
It was either June 10th or June 12th, but let me double check.
Well, she's looking for that, Your Honor. May I
Please go
proceed?
ahead. Yep.
Okay. The only thing
And the only thing that backs him up is, there was a key cycle on her car. And that's where they get their information from. But the key cycle that they're referencing to is the key cycle when Massachusetts State Police had custody of her freaking vehicle and they were backing up to get her car on the fucking flatbed.
important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside.
Where's the 42 minutes? Where's the 42 minutes? What are you doing? Yawning or what are you doing over there? You should be disgusted by this, sir. This is your brother's investigation that they're talking about. You should be appalled that this is the way they handled your son's death. But okay, yeah, just blame it on her. Why? Because she's an outsider.
The Sally Port that doesn't show much of anything.
She didn't grow up in Canton. She wasn't from that area. Yeah, blame it on her.
It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it and he received it. according to Sergeant DJ Petro. And it wasn't turned over either.
I know you trolling, West Side Writer. You always be doing that. She's innocent until proven guilty, sir. You can't say she's guilty unless you watch the full trial. Now, when you watch the full trial and see all the evidence, then you could say she's guilty. So quit trolling me.
None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is the definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible with all this sort of years-long flurry that we've just talked about surrounding these Sallyport videos that the actual trial prosecutors were completely unaware of their existence? Okay,
sir, you got me there. You did get me there. You're exactly right. It's ass backwards. You're right.
Until Proctor testified.
She's already had one trial, and to me, she's innocent. So, yeah. This is her second trial. It ended up in a mistrial because of all the BS going on. Obviously, I don't know what was wrong with the first jurors, because there was juror tampering, of course. But yeah, I don't know why they couldn't come up to a conclusion. Why? Because they take sympathy from the family here, because they believe the BS lies that the state has told them, or the BS other cops that were at the house, and the cop's house that was owned, that owned it. They're taking their side and believing them and not really following the evidence. They don't care. She's guilty because she dropped him off, even though he's an adult. And you can't force somebody to do something they don't want to do.
Before the federal grand jury, is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. Proctor lied to us. Could he have lied to them? I suppose.
But they're still
mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor.
Preach.
And then we move to January 28th, 2025, this year.
You are one of the same.
We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed or driven into the Sallyport garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Sallyport.
Imagine that. Any other time, it's perfect video. It doesn't need to be replaced. And the video that was almost perfect, they replaced that camera because it was defective. Yep. That's what they say. Which that is new evidence to me. I never knew that the camera that they replaced was the only camera that they actually got clear video that they inverted. Ain't that a bitch?
The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, the last 2.5, 3 years? Again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors have never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you.
Look the other way.
Commonwealth, in quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry, it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went and why we don't have them and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else.
Then in that case, if it's like that, it should be in the benefit of the defendant. That is exculpatory evidence. It can't prove either side. So the benefit of the doubt goes to her, not the Commonwealth, her.
That these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents. Particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wrong or unfairly treated or suffered harm or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith. And this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument. But the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional. The defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there's misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298, 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and finds that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury. And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession, and it was also entirely withheld from the defense throughout this litigation and throughout the first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though, and it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic.
Camera that they
For
had
the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the exclusionary rule exists.
I understand that does not help the defense.
It doesn't help the defense. I appreciate the court finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the Proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just for the court's reference, lines 8 through 12.
Great.
Thank you.
I have a question, Mr. Jackson, just about, so you argued obviously the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked, rather than shattered and missing 47 pieces, as Dighton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claim is read, struck.
See, she's adding 47 pieces into Sergeant Barrows's testimony. The only cop that's not conflicted in this case, mind you, he said there was a piece missing, not fully broken, not completely broken. but yet all the pictures that they want to show you, it's completely freaking broken. But okay. And so she's saying, I didn't see anywhere in his testimony that he said there's 47 pieces missing. No, that is what Proctor and them said. When they put the taillight together, put all the pieces together, all except for the one piece that she was missing because she backed into his car going to look for him. Only that piece they couldn't find, of course. But they found 47 pieces, and they didn't find it that day. They found it freaking that night in 1.5 feet of snow, and then for weeks on weeks on weeks, but no chain of custody. And his DNA was on the taillight. Well, their boyfriend and girlfriend, he's living there. Of course, his DNA is going to be on there. I'm quite sure he's touched the back of that freaking car. To get groceries out and whatnot, but whatever.
Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrow's testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrow's testimony.
Well, it sounds it from this, so I'm not to read it this way.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrow's testimony.
No,
As Dayton Police, Barrows testified. All right, so where do I find that 47 pieces?
The 47 pieces, I can get multiple transcripts. Those are the photographs the Commonwealth presented at trial, but there were that many pieces found at the crime scene.
It's the number of pieces that were booked into evidence.
Okay, yeah, great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it, because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight recovered.
That's not clear to me the way this is written, so I'm glad I asked you. Okay.
Whatever.
So with that, now, Ms. Tinetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with the question for the defense,
and you're all nice with him, huh?
I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sally Port videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video and will help create the foundation so the court can understand and perhaps the defense can best understand.
All right. And just like I did with Mr. Jackson, if I need to, I'm going to interrupt you to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys.
Yeah,
Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sally Port area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial.
Okay.
At that point, there had been no request by the defense for video of the Sally Port area. What I learned is that Trooper Proctor had requested Sally Port video from the Canton Police Department. And the person who was the custodian of Canton Police Video, who would download it from the DVR, was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments and that contained the front wall blurry camera inside the Sally Port and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant GM Petro
Even though we already had it?
for different cameras. He wanted cameras, camera angle of outside the Sally Port area. So when the tow truck dropped the car off, leading into the Sally Port, which is now characterized as the exterior Sally Port video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sally Port video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified, was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022. I'm sorry, it was provided April 4th, 2022.
2022 or later?
No.
It was later, right?
was
Because
later.
the federal grand jury was later.
He provided it on the eve of trial. So it was April 4th, 2024. So we know this production on April 4th, 2024 was in the hands of Trooper Proctor in shortly after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior Sally Port. As trial began, there still was no specific order or request. The chief of police saw something about the trial, and let me rephrase, prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera Sally Port was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yannetti's concerns, then asked Sergeant GM Petro to see if there was another camera or to produce any other video from the Sally Port. Sergeant GM Petro then downloaded video from the DVR, which is the second camera that is inside the Sally Port, known as the inverted camera, or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior Sally Port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the Sally Port and looked at the system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives. And because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial. The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that that video was copied during the trial. And it is noted in the sergeant's letter, the chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion or from their perspective, to help defend against future false claims against them. They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately. The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I've said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station. I learned about the videos. And then as a consequence, I spoke to the chief, other officers, and the sergeant unexpectedly. The sergeant told me that he would click and drag copies of video when he would download them from the.
See, all this playing catch and mouse. All this playing catch and mouse. Why? Because somebody has something to hide and they don't want the defense to see that footage. They have something to hide, which is sad to me. And you act like, oh, I'm trying to help them out. I'm trying to help them out. No, you're trying to help the Commonwealth be as corrupt as always.
The DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything. So I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Buchanan's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Buchanan to write reports. Since there was no chain of custody,
Of course you did.
I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Okay.
Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none. There's absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose. And again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just characterization by the defense.
John.
The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There
I
was
haven't
none.
done it.
There was none.
But you
Now,
guys
Trooper
do.
Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume.
But they
They
only
gave
gave
you
you
a
a little
fragment of his
piece.
testimony, which is about 3 sentences. But if you actually
There you
read
go.
a number of pages of his testimony that deals with this video, and it begins on page 133. What you will see,
The look
and
on
I
their
won't spend a
faces
half
when
hour
he
reading
says
it, but
this.
what you will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after
This-
January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton police. And you can also see that he in no way was hiding the June 2023 video, because you can see the confusion between all the parties at trial. Attorney Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a Sally Port video, and also there's an exterior video outside the Sally Port. And it is clear that Attorney Jackson does not have that June 23 exterior Sally Port video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Sally Port and there's the exterior video. So clearly Trooper Proctor
you
was aware of the
testifying?
exterior Sally Port video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or
That's a
advantageous
lot of
about it,
oversight.
because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course.
Lies.
And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important,
It is.
It is
'Cause
important to
anything in
note
question should go to
that the
the
defense
defense.
never filed a motion for the production of the Canton Police Department video. It is not incumbent or assumed that the Commonwealth is going to
Oh,
obtain
just wait till
every video
justice is
from every part of a town during an incident. It's not assumed that they will do that.
ever.
The Commonwealth seeks evidence that they think is exculpatory. They seek evidence that they think is relevant material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot. Put in context that the defense theory was a evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe. In fact, if you see earlier interviews,
It
the
wasn't
defense position publicly was,
unidentified.
you know exactly who did it, intimating that there was a specific person. Now, that recently has changed. If you see the recent interview 2 weeks ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not noticed to put the Commonwealth on notice.
It's
They're
not
supposed to
their
chase
burden
down
to
every
prove there, bud.
potential idea or creation that the defense has.
Quit burden shifting.
It's
'Cause you
important
can't prove your case.
to look at the motion that has been presented to your honor on behalf of the defense where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved
That goes against
to
the
compel physical evidence. That does not put the
rules of
Commonwealth on
procedure
notice
there, sir. And he's
of
going to.
video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know that the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
And so
It shouldn't be
Attorney
any.
Yannetti,
It's the
and I
government.
mentioned this before,
Period.
was very prolific in his pretrial discovery motions, very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact,
They've been
when
asking
you
all throughout
look
this
at
case.
the perspective of Attorney
What are you
Yannetti,
talking about?
you don't have to look much further than his characterizations of how he sees the difference between the crime scene in the Canton Police Department. I've attached for your honor and for the defense exhibit number 4, trial
The murder
testimony
weapon.
of Trooper Nicholas Garino.
The murder
And when he
weapon. And where it's
cross-examines
out.
Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard pressed now at this moment where they are trying to create prejudice that doesn't exist to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that that includes Canton Police Department because the Canton Police Department is somehow the crime scene.
Canton Police Department was housing the murder weapon. So technically, it's the crime scene inherently.
It doesn't convert. In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally.
Yeah, supposedly her car is the murder weapon. So if it's housed at a police department, that is considered basically a crime scene. Because, I mean, it's where evidence is. But yes, her car would be the crime scene because she had a cracked taillight, but all of a sudden it miraculously broke into a million pieces. Yeah. But they couldn't find the piece that she cracked on his car by hitting it when she backed up to go find him that morning.
And watch the inverted video. He was asked, were you shown any of the videos that you've seen in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting, I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. Answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they asked you to reach that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony.
And people lie on the stand.
Now,
You should know this.
Again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. And so you have to look at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So
Do you have the grand jury cite? I think I might have got it from this little earlier, but the grand jury testimony of Brian Higgins. I have it. It's just easier if you have a cite to that.
I have it tab, but I don't perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it.
I'll provide it momentarily.
All right, thank you.
So what really arises from the subterfuge is that the defense did not ask for video There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor. That
There was
wasn't.
only
There
some
was
video
nothing
provided
done
there
to
and
alter or
provided
change the video.
all.
There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's
because you're supposed to hand over all evidence. It doesn't matter whether it benefits you or them. You're supposed to hand over all evidence, period. And you failed to do that. You failed to do that. That's what prejudice is. That's what's prejudicing her from a fair trial, sir. All the cops in this case are corrupt.
testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately, the import of the defense's argument is that this evidence, this information is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is
Nick
Barros' testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told the story.
Very closely.
They're not completely damaged. That's exactly how we see Miss Reed's car later on after it is at Canton. The entire taillight is not missing. There is a piece missing. That piece, where the fractures of it
Not
are
a
found
piece.
at 34
The whole
Fairview,
piece
right near
is
Mr. O'Keefe's body.
missing.
The
Was missing.
same
There
parts
was
of the
only a
taillight
little
fragments that are
piece
found in
there,
the sleeve of
sir.
his shirt.
When
And so
you
it's
guys
not
got your
simply
hands on it.
cracked. Even the witness they tried to lean on, Mr. Barros, says more. And so if that taillight is not just cracked, that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring because there can be no plant of fractured taillight if it's already gone before it gets to
It
Canton.
wasn't.
There can't
sir.
be. And so when looking at the evidence, it is
Why could your freaking crime scene text put the whole taillight together and the only thing that is missing is a small piece? One small piece. But the others, they miraculously found, under a foot and a half of snow and 2-3 weeks later by just, randomly driving by and they see, a bright, shiny piece of red taillight. You are, I hate liars.
is unequivocally clear. That piece of the taillight is missing well before that car ever gets to Canton. And so we can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the fact, the claim that the Sallyport videos.
When you're the one, you are a defense attorney. And you're doing this to your brethren is crazy. All for a dime, though. Money talks, bullshit walks, I guess.
Were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense, and I just wanted Your Honor to see a small clip of that to show this condition, these conditions existed before this case.
And I can't wait for you to show it, because why would a pop-up come on about AI
Was even a moment.
Editing? Why would it come up if it wasn't edited, sir?
So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Miss Reed's Lexus hits the Sallyport area.
And that's in
And
yellow.
you can see, if you stop
That's
that,
in
please.
yellow.
Thank you very much. On that wall, on that garage wall.
Hurry,
there's a 4.
hurry.
It
Turn
is
it
backwards.
away.
This
Back
Sallyport
yellow.
video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan.
the inflection in his
It
voice.
was in
He's trying to
existence well
sound
before Ms.
convincing,
Reed's.
and he doesn't sound convincing. Why are you putting emphasis on it now, sir?
Car showed up to that Sally Port. Similarly, front row
Photoshop.
camera, could you please put on Exhibit 3? Exhibit 3 is from January 28, 2022, a day before Ms.
AI.
Reed's vehicle
I mean,
makes it to the Sally Port.
imagine
And you can
that.
see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police. This is the way the camera worked. You can't.
Lies.
Thank you very much. So the idea of tampering, we can
But why
claim
you
it,
got
we can assert it without
Photoshop
fact, but we can
and
prove it did not happen.
reverse?
Now, what we know is that missing
Why
tail
do you
light
have
was not
those on there
tampered
in
with because
AI?
it was gone hours before police even
Why you have those
touched
pop-ups
Ms. Reed's
on your
vehicle.
thing, sir?
At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at Exhibit 6, please. And this is from the Ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Sally Port video is relevant to show any break or planting of evidence. As Ms. Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in two spots so you can get a clear look of that rear tail light missing. Forward, please.
Not
Thank you.
missing there.
And then ahead one more. You
Hmm.
can see the
Only a
white
little
light.
spot. Only a little
Spot.
spot.
You
Only
can
a
see
little
it
spot
clearly
down here at
missing.
the bottom.
You can't plant something that's already gone.
It's not gone.
And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white.
Mhm.
The defense position is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial,
Now you want to bring in the ARCA witnesses, but I thought they, they didn't mean shit or whatever. But yeah, you're gonna try to mischaracterize their freaking statements too.
it's noted as Exhibit 10 in our package. Page 36, ADA Lally asks the good doctor, now,
Hey Daniel, happy Friday to you.
doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1,
Why should they be aware of that? They were only supposed to reconstruct her backing up to John O'Keefe at 22 miles an hour. They found no evidence of that.
now as far, line 2, now as far as you're aware from the review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by dash cam.
Okay, I would like to see you guys play it side by side with the one that was being shown before, way before trial. She backed in that sucker with no hesitation. She was going like 3 miles an hour without hitting her brake until until she got to the back of it. And hello, physics, friction, causes spontaneous combustion when say a certain part of the vehicle hits another part of the vehicle. It can do it. It's cold. All sorts of factors, but you don't want to put that into play, do you?
Cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that track.
And I bet you this evidence is doctored too. Let's keep
Okay.
going.
And when he did, he had a dash cam video further reinforcing that tail
Because the evidence that you just shown and the evidence that was shown at trial look totally different. It looks like you guys messed with her tail light to make it look like that. Because in the first video, I don't think I seen it.
light is missing well before.
But they want you to believe your lying eyes, right? They want you to believe your lying eyes. Believe that it's missing. Believe that you see that. Okay, cool.
That vehicle makes it to the Sallyport area. If we could play Exhibit 7, which is the dash cam footage showing Mr. O'Keefe's car in his driveway at 8:22 a.m.
Because she did it.
We
There's
close up
snow
the
on
photos.
it. It's not
You compare
showing
the
that
right
it's
side to the
missing,
left side.
sir.
Although covered and
There's
impacted by
snow.
snow, if you could more close up, please, you can see that taillight, just like the detective in Dayton said, just like the 508 ring video shows, is missing. Is missing. There's no plant.
You got Photoshop and Photo Ready. I
The
mean,
defense's
you got
position is
all
also
these on your
contradicted by the alarm.com
and this
video
little
that
pop
we
up
received
with
pursuant to
AI,
Rule
all
17.
that.
There are two videos,
Huh.
8 and 9.
But you didn't
You can
doctor
play
anything.
Exhibit
Where do you
8.
have editing software if you didn't do anything?
This is the defendant's car
See,
arriving
this
in
is
Dayton
the
in the
part
driveway.
right here where they back up her car to get it on a flatbed. This is the part where they say was the key cycle that matched the time of the supposed unaliving. But no, they miscalculated the key the key. What do you call it? The ignition cycles. They mischaracterized those and didn't go back further. But whatever.
The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping for? We can play video 9.
Okay, because they're looking at the taillight. But what about all the troopers that were gathered around her taillight in the Sallyport, sir? What about that? That's her car. She's allowed to do whatever the fuck she wants. But why was there no pictures taken before you even towed it?
And this is when the car is being put on the
There you
tow
go.
truck before
And this will be edited.
it makes its canton. And just like 508,
Here they go,
in the
backing
driveway
up
of Meadows,
real
to O'Keefe's
fast.
home, you will see that right
You
taillight
know,
shine white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
We cannot.
you
Can you
see a
zoom in on
little
it?
piece of white, little.
Your Honor, I would encourage the
Not
parties
the
to look
full
at it
thing.
on the computer. The clarity is much better, and it's very clear. The white light in this video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay.
If you look at it on a small screen, see right
I
there,
do see it.
and then you'll see it again.
It's reverse light.
So the alarm.com video contradicts the defendant's position that there is anything exculpatory
Small little
about
But it's
these
not the whole
Sallyport
time.
videos. In fact, this whole idea of third party or plan doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's
Mr. Reed, you need to go back and look at your own evidence of the of the ring footage and make sure that matches yours, because it sure seems like they love to doctor shit.
any relevance to the Sallyport video,
See,
that there's
there he
any
goes
type
with
of
that
plan by
infliction.
anybody, is from the defendant
That's where he
herself.
gets the infliction. Hold on.
Miss-
Any. All of a sudden. Like, dude, stop with your trying to prove yourself like you're telling the truth. It's just, the infliction is crazy.
Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at
There
John's
was
at
a
quarter
small
6
piece of
before we
taillight missing. You want to add a few. You want to add a few. And even a few doesn't equate to the whole damn tail light missing, dude.
Drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing.
But yet you guys didn't show that whole video. You only showed a little snippet of it. You didn't show any of it, sir. You didn't show when they're really looking at her taillight now, did you?
And some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court,
I don't
the production
remember.
should have been sooner.
I don't remember reading that. I don't remember that she said she dropped it in John's driveway. I don't remember saying that. I mean, her saying that. I think she may have said, and they dropped in John's driveway. May have dropped in John's driveway, but I do not think that she said that in the interview. And I'll have to go back and reread it.
It should have been cleaner. There should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen, but it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to the foot of the Sally Port, so there can be no claim. That is my argument regarding the Rule 14 issue.
And here you go.
I would like to
with the jury.
have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
You weren't even here the first
The
time.
claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen because of the collateral consequence of tampering with the jury. It would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss, it's not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. And why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fanning, not a coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked. There have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question, one of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well in the trial, as a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand. I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively. The next step is they have to identify a target. Who are they going to blame? Who's going to be the villain? In this case, a villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts. After having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened. When you look at the motion filed by the defense in this case, and they found their target, Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They tried to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the Pleadings Council, was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor, sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community, who are going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court personnel throughout this state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury.
Not
And
all
these
if
trial
we
court
can.
employees, especially here in Denham, some of the finest, would never abscond that duty. And yet it is now in the public domain, this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record.
Oh my God.
Fact: Lieutenant Fanning was not in charge of juror security. Fact: Lieutenant Fanning did not have control of the jury. Fact: Lieutenant Fanning did not access the jury. Fact: Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact: Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact: at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror. Fact: no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact: Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact: Trooper Fanning never investigated, approached, or inquired. He heard the information, provided it to the trial court, and is responsible, dutiful, and proper. And I'll repeat one more time: Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror.
Ever.
These claims in the motion to dismiss.
Not a fact.
Different issues, same thing, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
We should move to trial because I need to make my money.
Yes.
Thank you.
Because I'm a nerd. I'm Mr. Peabody.
Slam him, Jackson. Mr. Slam him, Jackson.
We're going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference, which is what we called it. So words matter. We claim that there's interference.
Yeah.
He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts.
Hey, Kevin, this guy's better than the
in
last.
just a second. Because this is a fact-based inquiry, one that we asked for, standing right over there at sidebar, and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts.
It's his motion. So, you know, when it's your motion, you get to go twice.
After facts, that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero.
Zilch.
And he knows
No.
that. But in an effort to create an enemy where there isn't one, he acts like we've insulted the court officers, which we haven't.
One person only.
He also said that Lieutenant Fanning stood up here and gave basically a CD, a resume for him, and said, greatest guy on the face of the earth.
Mm-hmm.
I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning.
Right.
Not really the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen when somebody else identified him. It wasn't us.
Bingo.
And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal. Mr. Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages,
Especially
etc.
the freaking owner.
When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer.
Mm-hmm.
We've seen that happen before.
Sure have.
The question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things?
But that didn't happen.
How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically?
Right.
And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who was then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course, it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that's in it to the courts, the actual courts security, the personnel security, the party's security to whatever degree that is necessitated, but maybe most importantly, the jurors' security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same Fanning that was just randomly picked to go report this to was also the person that was in Ms. Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed.
Mhm.
And yet we were denied an opportunity, Your Honor, an important opportunity to simply inquire before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here. Let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true. But lo and behold, minutes before I stood up to give my summation, that juror's removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right. Just a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Sallyport video and how unimportant it is. How unimportant that video is. And I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Sallyport videos if you're investigating a bar fight.
Mm-hmm.
This was the purported murder weapon.
Right.
This truck is the thing that the Commonwealth suggests was used to kill a cop. You think the video of it being pulled into the Sallyport might be of some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality.
No.
But I do know this. I do know this much. There's one guy who thought it was important. The lead investigator. He pulled it all of it. He was super, super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years.
Mm-hmm.
Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. Now, I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has a very, very good memory. We've never, ever disputed that the light was cracked at 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety, almost, except a piece was still missing. There was a piece unaccounted for. There's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant. And it's exculpatory. The condition of that light when it pulled into the Sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchnick, in front of a jury, present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page in sight now, but I remember it because I was sitting. He asked the question, did you see, Mr. Pryor, something I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Trooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of
I
that.
don't think I have. Sure. We can get that for the court immediately. Also, he played a video of the grainy video. So, and hey, look, some of these cameras are just grainy in other particulars as well at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. The video displayed was at the top. That's the exact same video. If it's apples and apples, oranges and oranges. Why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Sally Port.
Before Proctor.
With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot.
That I stood up in rebuttal and said that it was in court advocating for my client. He then said Court TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a Court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yannetti is referring to that comment that was a court comment. And so I intend on remedying that record. There was also a conversation afterwards.
Yeah,
All
of course.
right, so provide it to Mr. Yannetti. Mr. Yannetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me
Well,
what you
it's
want to tell me
just
now.
that right now it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it. And he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no Court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was arguing before Your Honor. I would just note, Your Honor, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. It's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds, that
You can take your time, Mr. Yannetti. You're not going to be
well, we're all
45 minutes.
right. I certainly will not be. This new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one, but I think perhaps he should apologize to the court. He said today, the lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's
I certainly do. So, Mr. Brennan, if
No,
you do
you
not
don't.
have a site,
No,
I
you
need you to
don't.
let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly, which is wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related the CNA's remarks, it wasn't in relation to 3.6, it was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide.
Or your request for the gag order in support of your argument for the gag order?
In response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It's exactly related to that point, not 3.6. But I will provide the videos. Mr. Yannetti is right, and the exact statement that I used was from a court hearing, but then there were subsequent statements made. So my regrets to Attorney Yannetti, but it wasn't in fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right. So if you have the site, I'll give you until tomorrow afternoon to find the Court TV site.
Very well.
If you have it, supply it to all, Ms. Gianetti. So I'm ordering the Commonwealth, if they have that Court TV site, to provide it to all of us. And if you don't, provide that as well. Provide that information.
Thank you.
Thank you. All right, that's it for today.
All right, support, please.
Absolute Jake.
You are
Yes,
muted.
damn this.
But anyway, so she's back in court for more hearing, or motions in limine on the 18th to find out what they can bring forward for evidence or in their exhibits and whatnot before trial begins April 1st, which is the jury selection. And then after that, she goes to trial again. In the meantime, she's still waiting on a habeas corpus decision from the federal government about the jury coming to some verdicts, but not all. So it should have been a pretrial, a missing, it should have been dismissal on 2 charges. But yeah, so anyways, this should be interesting. Thanks everybody that, let me remove that. Thanks everybody that came in, lurked, typed, shared, liked, all that great stuff. I really appreciate it. Thanks for helping me out. I do have a goal of getting my 1K and monetized because I'm not a $2 street hooker and I should get paid for selling myself on these YouTube streets. But anyways, I figure courtroom drama is fun to watch. Sometimes it's better than watching people drama because there's plenty of that on YouTube. So anyways, thank you very much. Everybody stay blessed and have a good day. Thanks for coming by. And remember, if you love and care about somebody, let them know that you love and care about them because you never know when tomorrow's not promised. Bye.
Turn me up, AV.
Put your eyes on me, yeah, like the spotlight. Recognize me showing love, then got my grind right. Ain't never since day one to love it on side. And since you got my back, I got your back for life. Yeah, pretty honesty. Know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you, dog, just what it gon' be. Definition of bestie, definition of friendship, definition of rider, definition relentless. She's a strong woman, she's a sweet lady, she's a great mother, let your pain get achy. Yeah, I made that girl on YouTube, she never dims my light or put me in her dark mood. And I thank you, you appreciate it. You're my favorite girl on YouTube, and I can't fake it. You still got faith in me, make me feel like big. DJ Khaled voice, pretty hot thing. Who still got faith in me, make me feel like big. DJ Khaled voice, pretty hot thing. Yeah. Met a little shawty on this show called BDP, you know what I'm talking about? Shit, we been cool ever since, my nigga, know what I'm talking about? Put your eyes on me, yeah, like the spotlight. Recognize me showing love, then got my grind right. Ain't never since day one to love it on side. And since you got my back, I got your back for life. Yeah, pretty honesty. Know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you, dog, just what it gon' be.